Well, welcome to Newsroom, Teresa Lusk. I'm sitting here speaking with attorney Byron Henry with Henry Hill Attorneys. Welcome to the show.
Great to be here.
Listen, we're going to talk about the Oklahoma Statewide Charter School Board versus Drummond case that has gone through the Supreme Court, basically. And this case is the Supreme Court is reviewing a case that could redefine the boundary between religion and public education. And in 2023, Oklahoma Statewide Virtual Charter School Board approved St. Isidore of Seville Catholic Virtual School as the first publicly funded religious charter school. There's a lot going on here because it has to do with giving a charter school money that has some religious ties. Byron, help us understand this case and what's going on.
So just to give you a little bit of context, the most recent Supreme Court cases, the last 3 or 4, have kind of continued a slow and steady march towards a neutrality principle that basically goes something like this. If the state or government offers funds across the board to private or public use, you can't deny them solely because the recipient is religious or has religious ties, okay, whether it's an individual or whether it is a school. So one of the more recent ones is a program by which schools could redo their playgrounds. You could get a state grant to completely revamp your playgrounds, make it safer, get rid of the old paint and put down the soft so kids don't get hurt. You could apply and they would allow that for all schools, including private schools, just not private schools that were religiously affiliated. And the Supreme Court said you can't do that. You've offered a benefit, a statewide benefit to all comers except religiously tied schools. That's not allowed. So this case is a little bit more of a twist on that. And that is charter schools get public money and they're kind of quasi-public in that they're public schools, but they're run privately, okay, and they're funded with tax dollars. So in Oklahoma, the board that approves charter schools approved a virtual charter school that is Catholic. Okay. So it's got Catholic curriculum. It's got the right to teach Catholicism and its tenets in class, just like any other religious private school would, but it's also a charter school, so it should get money from the state. And most state leaders agreed, but the Attorney General of Oklahoma did not, and believed the Oklahoma Constitution barred that funding for St. Isidore, and therefore filed a lawsuit, which the Oklahoma Supreme Court ruled that the Oklahoma Constitution did not allow it to offer the money, the state taxpayer money, to the Catholic charter school. That was appealed or petitioned to the Supreme Court. Supreme Court took it and recently heard oral arguments, I think on April the 30th.
Well, it is absolutely very interesting because how do you separate the two? How do you separate the two, saying this charter school is partially public with some religious ties, being that because of the constitutional protections, they can't be involved, but also they can't remove the rights for them. So what are the pieces that separate them that might even possibly give them a favorable outcome?
So one of the more direct routes and easy way to decide this, if you're on the Supreme Court, is simply to say, listen, all charter schools get funding. You can't deny it if they're religious. You approve this charter school, meaning that it's a charter school. You approved it, which means it gets the funding. If you don't want to give public funding to religious-based charter schools, don't approve religious-based charter schools. So that's the first problem, is that they approve, or a problem. That's the first issue, because it's already approved as a charter school. And I guess there's no prohibition in Oklahoma from approving religiously affiliated charter schools. Okay. So once that's approved, the Supreme Court say, hey, you need to give them the money because that's the rules. That's an easy way to decide it. But the more sticky question is deciding that without blurring the line between public and private, because I don't think the Supreme Court has ever come right out and said that state taxpayer dollars need to go to a sectarian religious school as a matter of constitutional law.
Okay. How did they even get to the point of being approved as a charter school if there was religious ties to begin with? Any idea on that?
Well, one, the board approved. They have a board that reviews all the applications for charter schools, and they were approved through the system. I suspect there is no prohibition in the mandate in Oklahoma law with respect to charter schools that you cannot have sectarian affiliation or religious affiliation in order to be a charter school, which could be an oversight, or it could have been purposeful. It could have been written that way to invite more groups to improve education and improve competition in education. So you had secular charter schools, you have religious charter schools, and allow the parents to choose the best option for their students.
That's actually a very neat concept, I think, especially in the state that we're in, and the state of education that we're in anyway. I think that's a great idea. Not that we're necessarily covering that, but should religious schools be allowed to receive public funding under charter school laws? Like if you look at it constitutionally, is that even right, appropriate? Where's the argument there?
So the Supreme Court has already held that if you have a system in your state, like Arizona has and Texas just passed this year, where money follows the student, that the money can follow the student wherever the student goes. Meaning it's not as much the state funding religious schools as it is the state funding parents and students, and the parents and students choosing to spend that money at a religious school. So that is the way they slice that thinly. But it is interesting, because that's what I'm saying. The Supreme Court has never actually said, state, you need to provide tax dollars directly to religious schools. They've always phrased it in the way of the students going to that school. The parents have decided to spend the money there. Yeah. That's not the state funding the private school. That's the parents funding the private school.
Well, that's actually brilliant. If they broke it up like that on purpose, that's actually pretty brilliant, because you can kind of break down that barrier of any kind of discrimination of where the dollars follow the child. Don't you think that's actually very useful?
There's 37, I think, states, maybe 38 with Texas now, that have some sort of school choice program by which tax dollars or voucher programs or education savings account programs or scholarship programs, tuition assistance from tax dollars for parents can go towards private school or sectarian religious schools if the parent deems it. So it's not new, and it has been blessed by the Supreme Court to that point. Okay. So now we're kind of at that point plus. We're moving to the next step.
Is that part of the reason why there's so much hesitation on the part of those who usually vote Democrat and left, is that they understand that this, if it continues in this manner, it does dismantle a lot of the public school system, but because a lot of times they are more anti-faith. Is that even possible, or is that just kind of an assumption?
I'm sure there's some animus from people on the left towards various faiths or faith-based schools. I think what's more likely is that it is a huge industry. I mean, it's only dismantling it to the extent that the public schools would admit that if people were given the choice, they would leave, which has always been an odd argument to me from a public school establishment that wants to prove to people that they're doing a good job in educating kids. They're saying, well, if you give parents the right to take their money and go to another school, they will.
Yeah.
I mean, why? Well, part of it is that the schools aren't doing a great job educating kids. And part of it is just a one size fits all program in America for anything is terrible.
Right.
We don't have one size fits all in transportation or in food or in cars or public transportation or housing. We don't have one size fits all for anything. The market pretty much runs everything and delivers to you what you want, whether it's clothing or transportation or vacations. The only thing we have a one size fits all system, even at college, is not one size fits all, is public primary school education and through high school. That is the only thing we have that has basically had a government monopoly. And I think most people think that's not the best way to do it. And so these programs like these charter schools or other tuition assistance programs to private schools are catching on in a majority of the states.
So could it be considered a form of religious discrimination if we're excluding religious schools from charter programs?
Well, that's what the Supreme Court has set up to now, that if you offer a benefit across the board, you can't exclude solely on the basis of being religious affiliation, whether it's schools, students, programs, anything like that. So that's where we are. So my view is that the answer to that is yes in this case. If you look at it the way I put it at the beginning, kind of objectively, do you offer public assistance to charter schools? Yes. Can you withhold public assistance solely on the basis that this is a religious charter school? No. That would be the logical outgrowth of the prior cases.
Okay.
The problem with that is that there's a little interplay there, because it literally would be the first time I think the Supreme Court has said we're going the further step of saying, no, you have to physically send the taxpayer dollars and fund the school, not through parents, not through scholarships or vouchers, but literally the same as you use tax dollars to fund teacher salaries and buses and buildings. You have to do that for a charter school, just like it's a public school. And that has establishment clause implications, not free exercise. It has to do with whether or not the government can be involved in, one of the benefits of charter schools or private schools is that they're free from the top-down regulation of you must do this and you must do that.
Yeah.
That's what makes charter schools sometimes more efficient and whatnot. So the fear is that if this happens, you're going to get more government oversight over charter schools, and they're going to lose their effectiveness.
Well, it's very interesting how they're often very independent, the charter schools. But if they teach religion, I guess I'm still wondering, and I suppose the public still is then how is it still a form of public school? Because you said it's a quasi public school, right? So it's got a little bit of both. How then can we continue to label it a public school if there's religion attached to it?
I think it's not a public school as we're thinking of it when you say that. It's really saying it's a charter school and it's quasi private, public, however you want to slice that. It is a charter school, which means it's different. Okay. If it's a public school, we just call them public schools, but it's a charter school, so it's different. It has different rules, and I think the Supreme Court has long left the idea that just because some money flows directly or indirectly to religious endeavors, that is necessarily the government preaching religion or teaching religion.
Right.
Just because you fix up their playground or you have a grant program or a scholarship program for students. So I think we're past that. This is just a little bit trickier solely in that we've never had a case that needs to basically draw the line and say, is this a public school or private school? It's both. It's publicly funded, but it's privately run. And because it's privately run, I think the Supreme Court will probably lean towards, you've decided to publicly fund privately run schools. And if you're going to do that, you can't discriminate simply because they're religious.
I think this point that you're making is actually very important, because I think people who don't understand, they rule based on emotion, right? When they're looking at these cases, they're thinking just emotion. I did the same thing until I studied the Constitution, and I thought, oh my gosh, this changed my whole world. Now you see everything through the lens of, and I'm a very strong believer in faith, etc. But now you look at it and go, wait, can you get away with this? And why? And so it removes the emotion completely. And you said a lot of, I guess the concern there is, is the government pushing religion and teaching religion just because they're handing over dollars? But I think one of the things that people miss is these dollars, it's not like they just magically showed up in the hands of the government. They came from the purses of the people. Yes.
Yes.
So then they give it to the government to issue out. And then people assume, well, you shouldn't be taking my money to teach it. However, they have some of my money in their pocket. They have your money in the pocket as well. So then now it doesn't mean that just because you're issuing it to a charter school, that they are teaching and pushing. Talk to us a little bit about that. Address that.
Well, and then you could make the argument that the people of Oklahoma have decided to have, through their elected legislature board members, they've decided to have privately run charter schools that are religious, that are funded with taxpayer funds. And as you said, there's no such thing as government money. It's all taxpayer money. They may be redirecting it from our wallets to theirs.
That's all they're doing.
Things.
Yeah.
So, and they always call it public funds. I like the way it's phrasing whenever you're against something being done with your money. It's they're using public funds to teach religion. And the answer is they're actually using taxpayer funds. They're actually using people's money. But I think that there's the flip side of that people don't think of, is a lot of people are opposed to these religious affiliated private schools or charter schools taking public money, because they believe that is the government getting their foot in the door to regulate, meaning that they will lose their independence if they rely on government money. Right. So on the one side, you're like, well, you should treat everybody the same. If you should be able to use public money there, we should get taxpayer funded. But then on the other side, they're like, but as soon as the government starts providing that money, are they going to want us to take state mandated tests and have a certain number of school days? And are they, because homeschooling associations have the same issue, is that, Texas's new bill allows you to use the educational savings account for homeschool expenses. The question is, if we take that money, if we take part in that educational savings account, are we now subjecting ourselves to government strings? And so that's the flip side of winning this case, is that the government's involved in sectarian religious education. Now do they get to tell us what to do?
Well, I mean, I don't ever remember a time when the government gives you money and doesn't tell you what to do.
Yeah, so that's the fear on both sides. So it's not just a one-sided belief that we should get all this money on the religious side. We should be treated fairly. It's also, do we really want this? If you're a faith-based school, do we really want to even open that door? We've been doing fine. We don't need their money. We don't want their oversight. We're doing just fine, and kind of keep the government out of our schools.
Hey, and I mean, to each their own, right? If they don't want to take that money, that's fine. If you can live with it, if it doesn't intrude into your religious beliefs, etc., do what you want. If that's the setup you want to do. But I understand why. I get both sides.
Right.
I get it. So Justice Amy Coney Barrett did not participate in this situation. What might affect her recusal, or what effect might her recusal have on the balance of the court? And that might be concerning to some.
It is. I mean, there is, just once again, painting with a broad brush, there's considered to be 6 conservative justices of varying degrees, and 3 to the left of center liberal justices, if you want a shorthand term for that. And with Justice Barrett recusing, that leaves 5 conservative justices. And if, for instance, if Chief Justice Roberts, who is probably considered of that group, the center vote, decides to vote with the other 3 justices, then that would leave a 4-4 split, which would leave the Oklahoma Supreme Court decision prohibiting the use of taxpayer funds for the religious charter school in place until another case came up. So it would affirm that decision. So a tie. So you can't afford to lose. If you're on the school side, you can't afford to lose 1 vote. And so, as I said, the Supreme Court has been moving that direction, and Chief Justice Roberts has been not only instrumental in that move, he's also authored some of those opinions. So you would think he would be on the forefront of that. But this, at oral argument, he was a little hesitant. So you may think this is just a bridge too far. My guess is that the case is probably decided narrowly, and probably goes in favor of the charter school, but it's a much closer call than the other case that's pending there with respect to the Pride Month and the opt-out in the Maryland school district. That case is probably going to be in favor of the parents.
Okay.
I'm pretty comfortable making that prediction. I've been wrong before, but this one's a little bit tougher. Probably decided narrowly, especially if Chief Justice Roberts joins the conservatives.
Okay. So, and that was one of the questions that I had was, have the justices, for the most part, of the past few cases, have they been ruled on constitutionally, in your opinion? I mean, you're an attorney, you look at these situations. Do you feel like they've been constitutionally judged there? I
think the Supreme Court in the last 15 years has moved back to what the framers intended with respect to the the 3 clauses: free speech, free exercise of religion, and establishment clause. The spirit of that was never to stamp out religion from the public square, but to make sure that religion was treated equally and fairly, and not unfairly. And I think for a while there was probably 30 years where the court took every opportunity it could to say you can't have this in schools, prayer in schools, money, whatnot, and everything religious was basically banished from not just public school, but the public sphere in general, that the religious individuals were losing left and right, whether it was regulatory permits, sidewalk preachers, to public schools. Now I think the balance has, the pendulum has swung back. I don't think it's swung back crazily, but I do think it has swung back to the point where now you can get even-handed treatment. With the government's putting money out there, the one thing they can't do is say, you can have it, you can have it, you can have it, but you can have it solely because of your religious affiliation. And that, I think, is a major change, but one that is in line with the Constitution. And if they keep following that precept, I think that's pretty much in line with what the framers intended.
I was going to say, but that's the whole point here, that you have to understand that ruling in the favor of the charter school is going back to the Constitution. It really is going back to the founding fathers, what they believed, why they did it. And I think that's where a lot of Americans are misled, especially in the society of a culture that's all based on emotion, and this offends me, this doesn't offend me, etc., which has nothing to do with your emotion. It has everything to do with, what were we set up to care about your emotions, or were we set up to protect your freedoms, right? It has nothing to do with that. So I understand what you're saying about them. They leaned towards a anti-faith I don't think we're clear from that yet. I don't believe that at all. Just even listening to these cases and the sentiments of these justices, it's very strong, very anti-faith. So with that being said, would it create a path for Christian, Jewish, and Muslim and other religious schools to become state-funded charters? Do you think that we could see that movement?
Absolutely. If the state allows charter schools that have a religious affiliation to be recognized, then absolutely. This decision would mean if you allow that, buyer beware type of thing. If you allow that, you're going to have to fund them equally with all other charter schools, including non-religious charter schools. So I think that that's exactly what will happen. And what you were saying about that, the whole pendulum swinging back and going back to the Constitution, is basically the misinformation is that the justices are trying to, for the very first time ever, allow taxpayer funds to go to religious endeavors. What a more accurate headline would be for the first 150 years plus of our union. First of all, there weren't public schools at the very beginning anyway. So, but the Constitution meant one thing, and then from the 1960s to basically the early 2000s, it meant something else for a small period of about 40 years. And now the court is going back to the understanding of the Constitution that was followed, the understanding that was followed for the vast majority of the life of our country. So while it is true, this decision would be something new, it's only new in the fact is that it reverts things back to the way it was before, and it doesn't follow the 1960 to 2000 version of the Constitution that basically said religion isn't welcome in public at all, including public schools.
Well, I think there was a submission to the meaning of it that just lacked, and so actually it makes me wonder why did that happen? Were there sort of specific Supreme Court justices that were very anti-faith, so they were going the other way and started swinging the pendulum the other way? What was the reason for that?
So there's appointees that were left of center, at least on those issues, and then just a very misguided interpretation of the First Amendment, which basically the Establishment Clause, which was put in there to keep the federal government from setting up a national religion, which would oppress the states and affect their ability to have their own religion, by the way, which there was no prohibition when the Constitution was ratified from states having their own official faith, by the way. States could have an official religion. That through Supreme Court precedent was overturned and basically said no, but nothing ever really changed in the Constitution. But the bottom line is that it went from the state not being able to have the nation not being able to have its own religion to any time any government, state, local, anything, has its hand in anything religious, even if it's like a cross in the crest for the city, or a religious symbol in the state flag, or a cross at a public cemetery, that somehow offends the Establishment Clause. So there's the two differences. And so once you take the latter interpretation of the Establishment Clause, you get that 40 years of jurisprudence, which basically said, no, you can't have a nativity scene outside City Hall. No, you can't have prayers at city council meetings. No, you can't have a flag that has a Corinthian cross on it. You can't have anything religious that has to do with government at all. You can't have chaplains. And so that was a departure from the original meaning of the Constitution, but we're getting back to, I think, what the framers intended.
Well, we're actually, if you really look at all the framework, the original documents, everything had God, everything had pointing to the God of the Bible, whether people like it or not. I mean, it's true. If you do your homework and research and read, you will find that all of these what were they called? Like the
founding fathers, the framers,
but their paperwork, their documents, the framing documents, they all pointed back to the God of the Bible, and they were so pro-faith, it was amazing. Now, there were some exceptions here and there, but most of everything that they were, if you look at all those documents, they're very much about faith. And so when people become very anti-faith, it kind of gives me a little giggle on the inside, because they don't realize what they're doing.
And the founders didn't have any problem with having people of faith in government, or even espousing their views, or government espousing certain religious views. What they wanted to avoid was religious persecution.
There you are.
So the whole goal is not to have religious coercion or persecution of those that were in the out group. So if you had a Christian nation and you had a group of Jews of Jewish people living in New York or in different areas, or Muslims now, or whatever you had. What they didn't want with those people persecuted for their beliefs, treated differently,
because
taxed differently. Exactly.
Yes.
They did not have a problem with a minority group having to deal with a Christian country or Christian legislators or even a Christian message from government, so long as they didn't coerce or otherwise persecute the minorities. That was the original purpose.
Yes. I just think it's become so threatening to so many people who are in government. So now it's become an anti-faith. And, I think this is part of the reason why these cases that are going before the Supreme Court in this moment are so important, because like you said, even 60 years back, you see the pendulum swinging. And if they rule a certain way, we could see it then go back to the way that shouldn't have been, really. So that's why these cases are so very important. Wouldn't you agree?
Yes, and it's a very subtle interpretation of the First Amendment. It's a very subtle difference between justices in the middle, left, and right on the free exercise, the interplay between the free exercise. I mean, you don't have to be a Marxist. Mm-hmm. With respect to religion to take the view that some Supreme Court justices and some very distinguished writers took on the Establishment Clause that got us the decisions for basically 40 years that used it as a club to drive out religion from the public square. You don't have to be an extremist. It's just very subtle differences in the belief of what the Establishment Clause does. And it can lead to schools that are completely devoid of any faith, even where kids don't even think they can say blessing over their lunch in the lunchroom. It can be that crazy, a very subtle change in interpretation. So that difference is all the difference. And recently they overturned what's called the Lemon Test. They overturned that after years and years of saying that it was no good, but never overruling it. But once that was overruled and they went back to a more text-based, intent of the frame-based view of the First and Second Amendment. The First Amendment, the Establishment and Free Exercise Clause, that was a world change with respect to these cases.
And that was thanks to Coach Joe. What was his coach? Who I'm talking about? Yes. There was a movie made of him.
The coach that knelt on the 50-yard line after every game and took his case all the way to the Supreme Court. He was fired for praying after
that's
the game.
Where it was. That's where it was overturned.
And they basically decided the Lemon Test was they'd been following it for years, but in that case, they not only overturned it expressly, but they also set out the way to address these cases. And that is a major move going forward with the way these cases need to be addressed.
Absolutely. And that's exactly why, Byron, I'm saying it's so important how the Supreme Court rules in this time, because it's going to set precedents for the future and for how we see even religious freedom. I saw so much religious persecution under President Obama, under President Biden. And we then saw a little bit of a breathing room with President Trump. Praying it continues that way for everyone. Anything else we should know about this case? It's so fascinating, all of these.
No, it's another big one, and it's likely to come out in the last 2 or 3 days of the court session, which is usually the last week of June.
All right. Well, we're looking forward to hopefully getting a favorable outcome for the charter schools. I think it's, religion isn't an imposing on other people. It's just having the freedom to express our very own faith, regardless of what faith you are, whether we believe in it or not, or agree with it or not. It's every American's right to express and enjoy their faith, their practices of their faith, or not. I know that's hard for some to hear, but or not. So thank you so much, Byron, for bringing forth your expertise. It's always great to have you on the show.
My pleasure.
And there you have it. You have been joined in with Newsroom Teresa.